Hello and welcome to the business Q&A sessions with Nita and Tosh. Hello, Tosh. How are you doing?
I'm doing good. Yourself?
Yeah.
What's with this Charlie's Angels look now, Nita? This is a new thing, right? Hey?
Kick back to the 70s. All about the retro. You know what? As people have, retaken stock of their world and thinking about what's going on, a lot of nostalgia has resurfaced, if you like. So, this is my bit for that.
Looking good, I've got to say.
Thank you very much. Right, well, today we have quite the topic, don't we? All about employment tribunal claims and how to be on the winning side. Do you think you can be as predictive as to say that sitting with us for the next 30, 40 minutes should give somebody the tools to be on the right side of the outcome?
Absolutely. And it's also about reframing, right? What does winning mean? There's ways of losing a case and still winning, as odd as that might sound. So I'm going to frame that in the right way. What I'd like everyone to have after this whistle-stop tour, I suppose, is a real understanding of what to expect in all the different aspects that I've seen clients have headaches about over the years. And what are the things they need to think about, not worry about, what are they need to think about, what challenges are there, so that if they're facing it, it doesn't feel completely overwhelming and they know where they can get the kind of help. I'm also going to talk about the cost of these sorts of things and where you can get these things funded. It doesn't have to come out of your pocket even. I thought it was a relevant topic, Nita, because, there was a backlog of tribunal cases, obviously with the pandemic, and then it went to a hybrid status, so partly remote and partly in the tribunal. And they're kind of, it's still that kind of level, but a mixture of that sort of stuff. But obviously the cases are starting to now be heard. So certainly in a very short space of time, a couple of our clients are dealing with tribunal cases. So I thought that would be good to just impart on people, whether you've experienced it, not experienced it. I think this will be tremendously helpful.
Thank you. Well, we appreciate your expertise and you sharing that on the Q&A sessions today. As always, we have a chat box on the right here. I'm just going to type in a quick hello just to show you how easy it is. You can share your thoughts privately or for anyone to see. You can ask questions, but the more interactive it is, hopefully the more useful this time that you're investing into this topic will be for you. You can take it straight back and apply them in your world.
You know what we do? We answer. We designed this to be able to answer all of your questions. We are people that have experienced these things. Please ask the questions. That's what it's there for. If you're dealing with a situation right now, put your questions in the chat, or something that you're seeing and maybe becoming your way in this sort of room, then put them in the chat. Absolutely no issue. Or if you're shy for any reason still, or it's maybe more complicated and you want to take it offline, you've got our contact details. Reach out to us. We'll pick up the phone and talk to you, to see how we can help you resolve whatever the issue is.
Absolutely, and that's the best way we can add value back. This webinar approach is very much complementary to our business and not-for-profit network. So let's jump in, Tosh. Let's do this, because over 55% of employment tribunals that actually go all the way are ruled towards the employee. So much of what employers are trying to do here is to mitigate that outcome, right? I mean, ultimately, they want to have more control, less surprises.
That statistic creates the myth for a lot of my employer clients that, tribunals just decide in favor of employees, don't they? Or they'll watch what's in the news. Employee gets £185,000 for flexible working claim. Well, obviously they'll be in the news because those are newsworthy. You don't hear about the millions of other tribunal cases or hundreds of thousands of tribunal cases that are won by employers. They're not as sexy, so to speak, right? It's like plane crashes. Nobody hears about these things happening. You get it in the news, and then suddenly you're hearing a lot of these things sort of happening. These things have always happened. It's just about how they're publicized. So that is a myth, and I'm going to give you a behind the curtain view on the way that tribunals and judges actually make their decisions.
Okay, well, that's what I was going to say, because my understanding from what I'm reading about tribunals and what you've discussed as well in prep for this is that actually the way judges are looking at cases has shifted and the way they're ruling has changed.
It hasn't. The principles are all the same in how they have to think. They what they have to. It's not about just justice being done. It's got to be seen to be done. So the way that when judges make a judgment, they've got to really lay it out step by step what their thinking is and how they've come to their decision. We work with employment judges, as in on our outsourced consultancy team, as well as working in the tribunals. So, it's interesting to know that, their motivation really is to do the right thing. It just so happens that if it's in favor of the employee, well, maybe the employer did the wrong thing.
Indeed. Well, something again that's so key at the moment is retaining talent. And again, so many employment tribunals could be avoided through mediation or just an honest conversation. And I'm actually asking in our poll today, so if you've jumped in and you haven't given us your feedback on the poll, please do. And this is asking whether you, as an employer, have experienced this great resignation. Apparently, the headlines go that 1 in 4 people will resign. And that's because of the pandemic and shifting priorities and people just really reevaluating their life. So we're asking you whether you as an employer have felt that experience and then rehired as a result, or yes, you've seen people go, but you've kept the team consolidated for now, or whether you preempted this and you're putting preventative measures in to retain people, like coaching, training, revisiting payroll and bonuses, or that you just got lucky. So if you could give us your thoughts on that, we'll publish those results at the end. It's really interesting because retention is everything at the moment, Tosh. It's really tough getting the right talent out there at the moment.
I think we discussed this as recently as last week, Mita. It's an employee's market right now.
Yeah.
So getting these things right and understanding how you retain those things is really important. Retain those stuff.
Yeah, it is. And there are literal counter offers happening all around. So even if people have somebody in the process and think, oh yeah, we've done that deal, that person's coming on board, it's not a done deal until that person is well into their role in the organization. It's competitive. Yeah. So really how employers handle tribunals matters not just from the employee and the cost of that, but from what they're perceived as from the employees that stay in an organization as well.
Absolutely. The flyer that we sent out for this particular webinar, I'm looking down here because it's got the list here. It's got four topics or 4 areas we're going to specifically cover. The first one is how do you avoid an employment tribunal claim? Yeah. Second is what do you need to know to win a case, and what can you expect the cost to be? So those are obvious questions that a lot of companies will have. Yeah. What do you pay if you get it wrong? I always say, as you know, it's not about. There's no law that says you can't do something. Yeah, I'm not suggesting you do things illegally. There's no law that says you can't do something. Every single law says there's a consequence if you break that law. The law doesn't say you can't break the speed limit. Yeah. The law says if you break the speed limit, there's penalty points on your license or a fine or what have you, right? Yeah. So that's why people are prepared to break the speed limit, because they are prepared to face the consequences. Yeah. Whereas murder, not that everybody would want to do that, perhaps they would not face those consequences, or if those consequences exist, maybe there'd be more of them, right? Yeah. So understanding that means if you know how to manage the consequences and you're happy with those, well, that's also a way of winning a case, isn't it? Getting rid of it, because rather than incurring costs of fighting it and so forth, there's other ways to get rid of it. So what do you pay when you get it wrong? I always say is the starting point whenever I talk to clients. Start with the end and go backwards. And the last thing is, is some of the myths that a lot of employers have about the loser paying the winner's costs and, tribunals judging always in the employee's favor. We kind of covered that already. But those seem to be the things that I hear clients complaining about or concerned about. Yeah. Okay. Right. So let's jump in. Question 1, how do we avoid employment tribunals in the first place? So what an employment tribunal case, if it's got an employment tribunal case, there's been a dispute. The employee is unhappy about the situation. There's lots of things that happen before it goes to court. And Mita, I'm going to get you to start on this one. Yeah. Where do you think the starting point is to nip something in the bud?
Good. It's all about the retention that I talk about. It's making sure you've got the right policies and procedures. You induct that person well. What you say you're going to do, you do. And if you can't, you tell, you build that trust and confidence. You train them well, you manage them well, and you have you represent the organization and you want the strategic objectives. But I believe you treat your people holistically so that if they have a challenge, they can come and talk to you about it off the record, or they have, somebody in the organization they can go to. So all the things that every employer should be doing as standard.
Absolutely spot on. Yeah. What? In other words, I'm saying the same thing as you said. Really, is how about a conversation? How about creating an environment or a culture where if there's a problem, we go and have a talk about it. We don't start slapping in grievances and shouting about things. Let's resolve these things. If there's that kind of approach in that kind of the workplace, you nip things in the bud. Yeah. You know how a grievance starts. It's something, a conversation that's going in somebody's mind about something, about bullying, about whatever else these issues are. And if those things are happening in the workplace, generally my experience says that the company are allowing those things. We've got to be able to show this is not the way we operate. We don't commit that kind of behavior or whatever it is. So what I'm saying is create the environment, or at least create an avenue where employees can get help if they need to without going through a formal process. An adult conversation. How about that?
And so if an employee were to, bring up a grievance and an employer doesn't want it to go through the grievance process, which then might sort of take it into this them enough feel, that's where mediation comes in, right?
Yeah, it can do. What you could do, it's the employee's grievance, right? So it's for the employee to decide whether they really want to take it formal. Why can't we say as employers that, why don't we try this way?
Yeah.
Let's try and talk. And if that doesn't work, the formal process is still open to you.
Yeah.
Now, this way can be just you going through the coffee shop and having a chat, quite frankly. It could be as informal as that and saying, look, what's really going on here?
Yeah.
Or if you want to get a bit more formal or get a professional in, obviously that would come at some sort of cost. You get a mediator in and you get the people to sit down. That normally happens when there's like a miscommunication or a bullying between employees, or, two people clashing heads or something, and then getting them together to see from the other person's point of view, if I were in your shoes.
Yeah. And are there, so there's sort of two types really, as you said. There's the types that are people related and could be around protected characteristics or people feeling bullied or harassed. And then the other side is where an employee may have an issue with their contract or the way they've been treated by an employer.
Correct. And that the treatment might include being unfairly dismissed in their view. They didn't understand it, or they felt it was unfair, or they felt that things were unjustified, or whatever the sense of justice they had, they feel aggrieved by it.
Yeah.
So your door open there in the background.
It's like a ghost.
If I was waiting for someone to
I promise it's not a ghost. It's the puppy who's managed to learn how to open doors.
There are other ways of doing it, which is a real common sense approach. A lot of people get a grievance, for example, and think, oh gosh, let's call HR, let's do that. That's fine. Try and have a conversation. The ghost closed the door again.
I know.
The dog, is your dog closing doors now?
That good.
It's like Velociraptor, isn't it? Anyway.
I know.
There's lots of ways of doing it. So it's okay, because if the employee says, no, I'm not happy with this, I won't do that, that's fine. Then we'll go down the formal route, which I'll talk about in a minute. Okay.
Yeah.
So absolutely.
Because the extreme end is then unfair dismissals, constructive dismissal, and the things that really catch an employer by surprise.
Yeah, absolutely. And remember, there are these internal processes, grievance, disciplinary processes, because if it goes into tribunal, you want to be able to demonstrate that you've done the right thing and followed the right processes. Not just remember I said earlier about judges. It's also the same with employers. It's not about doing the right thing. It's being seen to do the right thing. So document the process all the way through if it ends up having to go down a formal disciplinary or grievance process, which could then end up in a tribunal, right? Because
the other challenge is often with these dismissal cases, it's a perception of what happened rather than what might have been intended by the employer. So again, clarity of communication and the trust and confidence, keeping that in the forefront, hopefully should be able to avoid it. But what if it isn't avoidable? What if an employer gets slapped with an employment tribunal? Next part of our what we're covering is what you need to know to win a case and what the costs might be.
So there's lots of steps before it ends up in a tribunal. I'll do that really quickly, okay? The first thing is an employee, I'm assuming it's a grievance. Discipline is a different thing. I'll deal with that as well. If it's a grievance, they'll go through a formal grievance process. The employer has to look at all the evidence, has to form a decision. It's got to be an impartial and fair decision and reasonably given, right, based on all the evidence. The employee would have a right of appeal as well. Again, so you do the whole process again. If they're still not satisfied and they resign to claim constructive dismissal, or they don't resign and they want to claim discrimination, they've got to go through the ACAS early conciliation process first. That's what the law requires. That is a process that lasts up to 6 weeks. And to put it in, if anybody that doesn't know what that is, they're an organisation that are designed to resolve workplace disputes so that they don't end up in tribunal.
Yeah,
if that process, correct, right, and that might be to resolve it for money or whatever the circumstances are. It's an opportunity within a 6-week window to resolve it. Yeah. If it isn't resolved, then ACAS give what's called an ACAS early conciliation certificate number. Get my teeth in for that one, and you need that to be able to lodge a claim in the employment tribunal. then we are in tribunal. So if you look at it, we've got quite a lot of time to try and resolve it. And you know that phrase, I'm sorry, I'm sounding a stuck record, language shapes behavior.
Yeah.
It's not just what we say, it's the way we say it and why we're saying it. Just understand, assume the employee is motivated by something that has made them feel unhappy. Yeah. Let's assume it's not just to get money out of you. Let's assume that there really is something genuine. They think that's the only way. So it's down to us as employers, a little bit like children that don't know any better without sounding patronizing, to perhaps show them that's not right. This is the way, or that's the way, or what have you. So there's that point in the appeal, the grievance, the appeal, and through the ACAS process where it can still be resolved. There's lots of ability to talk, find out what they want to resolve it as well. Yeah,
and say genuinely to anyone, we're sorry that you feel this way. Don't assume blame. Don't say we're sorry that we did this. It's not that. It's saying we're sorry this has happened. We want to get this right with you, and let's work on that together. I know you're gonna have to ignore the door, Tosh.
Yeah, I won't mention it anymore.
Yeah,
you're absolutely right. So if it looks like it's going through that process, the way to avoid the tribunal claim is obviously to settle it.
Yeah.
So sometimes, understanding what the potential liability is, which we'll come to a bit later on, will make you think, you know what, I'll just get rid of this, because maybe the time in dealing with the grievance and the grievance appeal, or dealing with the disciplinary even, or disciplinary appeal in the ACAS process, you could spend that time earning money within your business, spending your time where it's better utilised, where those resources are better utilised.
Yeah, so, it's the opportunity cost of everyone involved. It's
absolutely. It's an opportunity cost, it's time, it's real money, it's all those things. And so imagine if the man hours it would cost, and paying lawyers or HR people cost of £3,000-4,000. I'm making that up, right? And suppose the person's salary is a couple of grand, and if they win at tribunal, they only get 2 months' pay anyway, which means it would only be 2 months' pay.
Yeah.
Well, isn't it better to just have a grown-up conversation? Because if something's not working out and you can't make it work out, well, let's just talk about what they would potentially get if they went to tribunal anyway.
Yeah.
So understanding the costs involved is on what the real potential liability would be is key to winning your case, or settling it, or resolving it.
Yeah,
not based on emotions.
That's right, educating the employee on what potential outcomes they could have. And we always do, for these sort of cases, employability reports, which essentially map the market and help an employer show the employee that if they were to have a loss of income, i.e. not be able to get another job straight away, this is the salary that they would have lost, or that they could go and get another job in a wider geographical area. So it covers salary banding, geographical area, and how quickly they should be able to find another job, which then helps employers negotiate, or in a tribunal, how much is actually awarded.
Yeah, I mean, you and I came up with that offering for our clients, and it's been tremendously useful in resolving all sorts of issues. So just to explain that in context, for an unfair dismissal claim, you're entitled to your loss of earnings up to £90,000 or your salary, whichever is the most, up to 12 months' pay, right?
Yeah.
Or it's subject to your ability to get another job. So what that in English means is, if somebody's on £2,000 a month and they can get a job within 1 month, the maximum value of the claim is £2,000.
Yeah.
Bearing in mind, forget basic awards and other bits, but essentially that's it. Pure economic loss. So if it's worth £2,000, well, then you really, their liability is limited. You might think, you know what, sod this, I don't want to deal with all this stuff. Yeah. I'll just offer them a severance package. And if they say no, well, we can just get rid of the situation. And then that's what they're going to end up anyway. Yeah. So your employability report produces a report that shows the person's ability to secure alternative employment. And we've used that in many of our negotiations with these types of situations. Say, well, look, you can get a job within a couple of months. No, I can't. Well, here's the report. Please feel free to call these individuals. It's real. This isn't just us presenting this. So they would be foolish almost not to accept it. So understanding how to negotiate a settlement and resolve, it's really, really useful in these types of situations.
Indeed, and prevent the tribunal from even base.
And you know what I always do early on, regardless of what your appetite is for dealing with these sorts of things, is find out what the employee wants. No point them just saying what their beef is. What's the problem? And what is it you actually want out of this?
Yeah.
We're not saying we're going to give it to them, but suppose they want something really simple. We don't need to go through the whole circus. We can just get on with it straight away. So that is the way to avoid an employment tribunal claim, whether it's got merit or not have merit, is to settle it. And that means, and don't get me wrong, I've known lawyers that have settled cases for a box of chocolates and an apology, because that's what mattered. So what does it take to resolve it? Well, let's ask and find out, and then take it from there.
Make no assumptions, because again, employers think employees want one thing when it really could be very simple and straightforward.
Correct. So get your processes in place, get your policies in place, know what you're doing in those types of situations. Get help from us, so you know what you're doing, or whatever services you've got there. And I'm going to talk to you about all different types of ways you can get help as well later on. And then that's how you avoid the case, because you'll show them that it's not worth their while. The juice isn't worth the squeeze for them.
So if it goes to court, we've spoken about the employability report can help an employer have a realistic and independent view. What other things does an employer need to have in place to win a case?
So the first thing to know, and it sounds really obvious, but it isn't, is know your case. Remember, the employee generally is bringing a claim. Yes, they may have done some Google research and pieced some things together and what have you, but it's predominantly run on emotion. It's how they feel. It's their sense of injustice. This isn't right. This can't be right. There's got to be a law that protects me. But actually, the reality of it is the law might look at things slightly differently. I won't go into much detail unless you ask me to repeat it, Mita. But you know that the way that judges decide things isn't beyond a reasonable doubt. It's on a balance of probabilities. So in English, what that means is it isn't necessarily the truth of what's happened. It's what does the evidence suggest has happened. So an employee might feel that they've been bullied, and that's right, and I feel aggrieved, I'm not going to stand for this bully, but the evidence doesn't support that. Whether it's happened or not is a different matter that an employer will only deal with the evidence to support it. And that means what people have said, whether there's emails or documents or whatever the circumstances are. That's different.
Look at the Yorkshire Cricket Club, a high-profile case at the moment, purely based on what one set of people thought was okay, right or wrong, and what other people perceived. And rather than taking on a complaint and dealing with it properly, this employer let things go. So it really is in the employer's hands to say, guys, we're going to do some training. This is what's happened. This is not acceptable on our part. And that would help them in an employment tribunal to be able to show that they took steps to prevent the issue that the employee is complaining about.
Absolutely. So knowing your case and understanding how it needs to be resolved also calms the employee down, because otherwise you've got somebody that's ranting about these things and my rights and so forth. And then they're almost setting the tone and the pace of how the grievance is being run. Employer doesn't have to sit back and just take nonsense. Just be firm and fair about it and take control of the situation, because the employee is running on emotions. So number one is know your case. What are we actually dealing with? Number two is, what's the liability? That makes all the difference on whether you want to fight it or not. There may be a commercial reality. The stats are above 80% of cases get settled. And sometimes at the doorsteps of the tribunal, they play a game of chicken right up to the tribunal hearing. So if that's the case, why don't we just go straight to that? A lot of employers will also take a stance of what's right or wrong, or we don't want to settle this case and what have you. The reality is, let's just face the reality of it. It's going to take up your time, and it's going to take up your money defending the case, even if you're right. So let's have a look at liabilities. What do you pay if you get it wrong? I've told you, so for example, unfair dismissal is up to a year's pay, or £90,000, whichever is the lower of the two, but it's subject to the ability to get another job. When you have that knowledge, they get in touch with someone like you, Mita, and they get a report and they find out exactly how long it will take to get another job. When they know that, they can make different choices, can't they? You know what, we're going to let you go, for example, because that's the maximum they could get. Discrimination claims are slightly different. They'll be in the region of anything up to £45,500 approximately for an injury to feeling awards. And sometimes they're uncapped if you can show that they can never work again as a result of the discrimination, maybe psychiatric illness or something very rare. But knowing those things also determines the level of seriousness and the resources you should put into dealing with this grievance. When we get a discrimination claim, I generally advise clients to hit it hard. And I mean, really have at it.
What does that mean, hit it hard?
So that means if it's an unfair dismissal or grievance, a disciplinary issue, unfair dismissal issue, or constructive dismissal, that's quite straightforward, right? It's just pure economic loss. We know how to deal with it. With discrimination claims, well, it relates to whatever the discrimination may be. It could be worth a lot more. It could be worth, injury to feelings could be uncapped, which means you could get your income up to the day you retire in very extreme cases. So hitting it hard means really do it properly. Be seen to be whiter than white. Follow the process. Checklist everything. Yep, we did that. We did this. And you want to be able to stand up in front of a judge and say, well, Judge, what else did you want us to reasonably do? We investigated, we looked at all these things, we checked, and the evidence didn't stand up on a balance of the probabilities in the employee's favour, assuming that's what the outcome is. So hit it hard and be very clear that the paperwork supports it.
And when would an employer get in touch with somebody like you, who would deal with, I know you deal with employers and employees and represent both sides in court cases and things. When would an employer reach out to you, Tosh, and say, Tosh, we've got an issue?
Generally what happens, Meet, so it can be at any of these stages, but the best stage is right at the beginning. As soon as the employee has raised a grievance or raised a complaint, whether it's informal or formal, just get some advice on, guess what? Know what the case is, know what the liability, you know your choices going forward. It's almost like a crystal ball, right? What are you in for? Then you know what you need to do to either avoid it or go for it. But it's always about your choices, and you need experts to be able to walk you through what you might be in for and whether it's worth it.
Yeah. So I'm going paperless, so I'm looking at my notes on my phone. So these are the steps you need to have to win a case, the people you need to have in your world, and really thinking about what goes to tribunal and what gets settled before.
Yes.
The costs we've covered, the limitations of costs or the uncapped costs and things like that. What about legal fees? Because there's this whole thing around, I hear about people saying, oh, I thought my legal fees would be covered. They're not going to be covered. How does it work in terms of the legal costs? Because sometimes legal costs can cost more than the actual salary compensation that would have been required anyway.
Absolutely right. So any solicitor you instruct has to tell you what you're in for. So if you're paying an hourly rate, they've got to give you a guesstimate, at least, and break down what that guesstimate is. Obviously, there may be some variables on that, because if it's an hourly rate, you're paying for time. Some things take more time or less time, but they've got to give you an idea. If it's a fixed price for the job, then you've got to be clear what that fixed price covers. Now, we do fixed prices, then you've got certainty of cost.
Yeah.
If it's an insurance case, so remember, you don't have to pay legal fees if you've got some sort of insurance policy. So lots of people will have it on the back of contents insurance. Check your company policies and see if you've got it. Yes. What that will mean is that they will want documentation to show that you can defend the case, or there's a 51% chance you could win. That's what you need to be able to show, right?
Right.
If you can show that with the paperwork that you've got 51 prospects of success, they will cover your legal costs. And if they cover your legal costs, they will also cover the case even if you lose. So that's what those types of insurance policies are. So check as soon as you get a claim through the door, check your legal expenses insurance, which should be on the back of some content insurance for the business, or content for the premises.
Yeah, and I'm sure there are a lot of employers that the left hand and the right hand aren't necessarily clapping, and they have insurance and never use it and just end up paying legal costs directly. So really, really good point. And
one other point to make is, if you've got your own lawyers. So for example, the insurance, we've got clients who've got insurance policies, and then they nominate us as the lawyers to deal with the case for them. Yeah. So the insurance will pay our fees. So you don't have to use the insurance lawyers, which is the panel lawyers, if you've got somebody who you prefer to use. So that's a great way of obviously saving the money for it, and also they'll also cover the cost of the settlements as well under those insurance policies. It might mean increasing the premium, obviously, next time round.
Of course,
but it's inevitable, like a car accident or whatever else, any other kind of insurance. Yeah. But it's a way to manage those costs, particularly if you're feeling gung-ho and you thought, you know what, I don't want to settle this case because I don't want to send out the message that we settle cases. We were right here, or something like that.
Yeah. Okay. So the final part is that you get to the end of a tribunal and there's a winner and a loser. We talked about insurance covering costs. What about this approach, the myth-buster part of this conversation, which is, does the loser pay the winner's costs?
So we always start with clients saying it's very rare that in county courts, those or high courts, loser pays the winner's costs, right? In the employment tribunal, each party bears their own costs. That's the rule. Each party bears their own costs. Doesn't matter whether it was a nonsense case or whatever else it is. But in some extreme cases, if you can show that, certainly in the England and Wales employment tribunals, so I've certainly had a different experience with the Scottish employment tribunals with slightly different rules, but rules. The rules are that each party bears their own costs unless the claim was brought or the case was defended just to cause cost and inconvenience. Right. If you can show that it was complete tosh, I'm the only one allowed to say that, obviously. If it was complete tosh, then you might be able to, but don't go in with that, because it only happens in very rare cases. Yeah. Scottish tribunals are much stricter. They take a different kind of view in those sorts of applications, and it's really, really just very, very, very unlikely. Okay. So assume you're not going to get it, but it's a bonus if you do.
Yeah. Okay. And it's not something that can be negotiated. It's just something you can check at the end. based on the outcomes of the court case.
Yeah. So what will happen is then it's only at that stage of the final hearing meter where the judge has heard all the facts, listened to all the evidence, and then they can see, well, that's nonsense.
Yeah.
You should never pursue that. You just wasted everybody's time. Right. There's a cost award against you for whatever the legal fees that were incurred were, or whatever the judge reasonably considers.
Okay, brilliant. So the final mythbuster we have is the stat I brought up at the beginning, which is that it seems that, first of all, judges are shifting the perception of what they rule in favour of and against, what's reasonable. Obviously, in the last 18 months, with employers doing this work from home and now hybrid case, a lot of employees are coming back saying that they haven't been. Will you tell me what sort of things are arising in terms of employees and hybrid working in terms of tribunal cases?
Well, the ones that are high profile, we've kind of covered in some of the earlier webinars, right? So flexible working has been particularly high. Crazy situations still where people are saying that, we're not going to consider your flexible working request for childcare. And it's not inconvenient for the company. Work half an hour less or something like that. I think it was an hour less in that particular case. Or an air steward who was, was told that she couldn't continue stewarding and those sorts of things, right? Yeah. So the cases arise. There's no doubt about it. But I really want to be clear. This is not lawyers having each other's back or anything. I'm not that guy. So I've seen it happen. I've spoken to judges. I've gone out with judges, socially for dinner and all those sorts of things. And they really go to a lot of pains to do the right thing. But the right thing are within the rules. So they're looking at the evidence based on a balance of probabilities. Yeah. They're looking at what which is the test. They're making sure that the arguments are presented cleanly. If the person is not represented, they take their time with that individual to make sure that they understand what they need to do. It doesn't mean they do understand it, but they understand what is it you need to prove to win your case. What is it actually about? Yeah. What you might find is they might, when you're represented, and that tends to be the company, they'll probably give the employers more of a hard time because they've got more cost, more resources, and they've got a lawyer, somebody like me there. Yeah. So they're bound to really put me to the test on things, whereas they'll be a bit softer with the employee. So it's not that they're deciding in favour of them. They just can't treat the employee like a lawyer. And similarly with the company, if they've got the resource and they've got a lawyer there, rightly so, have at me. Because I'll be able to defend the case and say what the situation is the point. So they might take that view, but apart from that, they very much go to town about doing the right thing, not just and being seen to do it as well. Yeah.
So they're not necessarily, it's not a higher probability that everything will be voted for in favour of employees. It's just the way judges go about it.
Absolutely. The statistics might indicate that more employees are winning. That isn't because judges are deciding more in favour of employees because they're employees.
And what about this new element of hybrid working? We talked about flexible working. It's really important, isn't it, for employers to be on that journey with employees? I mean, if we're tying this up today and talking about going back to what can help employers with this new added element of needing to retain people, needing to consider hybrid, which is what judges are doing now, and saying, well, come on, hybrid working is reasonable, whereas before they might have agreed that it wasn't reasonable. Now it's proven that it's reasonable. So it's important for employers to be able to go back to how to deal with flexible working challenges and requests, isn't it? And that's my question really, is if, we know that with flexible working, every employer, I'm learning from you, Tosh, has to take one application a year from an employee, and there's no right of appeal, is that right?
Yeah, so the first thing I'm going to say, Mita, was when they're dealing with these challenges is what you said right at the beginning. I put it in your court, right? Yeah. What do you do? What is the quickest way to resolve employment disputes? And it was nip it in the bud. And how do you do that? Talk. Yeah. Have grown-up conversations. Understand where they're coming from. See it from their shoes. Try and resolve it. Yeah. So that's fine. If it doesn't work, you go down a formal process. Unless the policy says something else, the law actually says you can make one flexible working request a year. Yeah. One in writing. And that means you make it. That doesn't mean you can then change it. If they say, I'll work Mondays to Wednesdays instead of the full week, you can't do that. All right, then I'll do Wednesday to Friday. No, it's gone. Yeah. So in terms of flexible working, and there's no right of appeal. Don't ask me why. There just isn't.
Yeah. And I think it's a question around employers saying, no, I can't do that because it will set a precedent. That's not enough, is it, for an employer to say?
No, exactly right. It's got to be about what's reasonable in the circumstances. The case we were talking about, the flexible working request of the employee who went and had a baby and came back. And what she actually asked was, instead of working from 9 to 5 or something like that, she wanted to work from 8 to 4.
Yeah.
And it wasn't an inconvenience. It wasn't something that they couldn't do. They just didn't want to do it. They got used to doing things in the way they've always done. And this is not the 1970s anymore. So,
that was the challenge there. They didn't even look into if there was a business a reason.
Yeah, absolutely right. It was a blanket no, and that's not what the law allows, and it's not what's right.
Yeah. So to sum up, employment tribunals, outcomes, or even getting slapped with one at all really is in the employer's hands, and they can do everything to prevent it. But if it does come to it, there's experts like yourself to walk them through the journey, hopefully help them settle or win the case. And then really it's about picking up the pieces, because there's an internal reputation for employers that are being taken to court for tribunals as well, isn't there? I mean, I'm sure you've seen that impact.
Absolutely. The key, what you just said there, Mita, is that there's tools out there to resolve it at whatever stage you're at. Don't worry. There really is. Don't worry about the expense. There's lots of ways to get around that too. Might not seem like it, but there is. And you think whether it's legal fees or paying off something, there's lots of other ways which we haven't covered today. Obviously 3 years of experience of getting around these things. So if you are somebody facing that, then help is there. It's genuinely what I'm saying.
Indeed. So we're a couple of minutes in left, should I say, for today's session. So I'm going to go back to the poll just to see where we are with that. So 75% of attendees today say they have experienced the Great Resignation, but they've also been able to rehire to overcome that challenge. So that's really good. And then 25% have said no, and they just think they got lucky. So I think there's always some success, some method behind luck. The harder you work, the luckier you get. So really, I think my closing message for this is do everything you can to prevent any kind of dispute in the first place. Have really good policies, procedures, keep talking to your employees, and let's remember that everyone's on the same team here.
Prevention is better than cure, and that's easy, but it's not too late if you're already facing a situation. There's always ways around it.
Indeed. Now, we've had a quiet room this week. No chats, no questions, no comments. So we're hoping that this was useful to everyone. And until next week, I'm going to say bye-bye.
Take care, everybody. Thanks very much.
Bye. Cheers, Josh. Bye.